This is Paul Fromm with the Canadian Association for Free Expression. I think we have a better chance than we did a few months ago to go all the way to the Supreme Court. And it's a very important case. It's called the McCorkle case. Robert McCorkle was a professor of chemistry, and he passed away in 2004 in New Brunswick, in St. John, New Brunswick. And he had quite a collection of ancient coins and artifacts. And there's some discussion as to what it's worth. You hear estimates all the way from $250,000 to $1 million, and until it actually gets to the point of selling these things, I guess we won't know. But let's just say it's a fairly substantial estate. And he gave the entire estate to an organization he'd become a member of, and this was called the National Alliance. Now, the National Alliance is a U.S. White nationalist organization based in West Virginia. Now, for reasons we're not quite sure, it took 9 years to probate the will. So not until the spring of 2013 did a New Brunswick court put its stamp of approval on the will and say that yes, this was indeed the last will and testament of the late Robert McCorkle, and these provisions meet the law. In other words, so the will can now be enacted or implemented, and the proceeds distributed. Well, it was at that point that the McCorkle will came to the attention of a very meddlesome anti-free speech United States group called the Southern Poverty Law Center in Montgomery, Alabama. They objected violently to the will. They said that if the money went to the National Alliance, it would revive Nazism. Well, this is a little far-fetched, you know. The National Alliance are not Nazis, but even if they were, that was Mr. McCorkle's desires to pass the money on to them. The problem for the Southern Poverty Law Center was that they didn't have any standing in a Canadian court, and besides, the will had already been probated. Well, there's an Ottawa lawyer who seems to devote a great deal of time to going after groups he doesn't like. Well, he says he's fighting hate. This is Richard Warman. He made a menace of himself in the last decade, filing human rights complaints against people on the internet that his views he didn't like or he would consider hate. And what gives him the right to judge other people's views? Anyway, that law eventually got repealed. But Warman, that's the type of thing he does. Anyway, Warman put out a statement that this will should be revoked or nullified because it's contrary to public policy. And I kind of wonder, what does that mean? Well, the argument seems to be that because the National Alliance promotes the white race, wants a better place for the white race, wants a homeland in the United States which will be for the European people, wants the values of the European people to prevail, to develop a strong, healthy, proud, creative people. For those reasons, according to Mr. Warman and those who think like him, it was racist. And Canada, so the argument goes, has signed international protocols to fight racism. That's a problem with signing international deals. Anyway, again, Mr. Warman didn't have any standing, so I put it down to being, well, you know, everybody's entitled to run their mouth at some point. Next thing we know, though, a woman named Isabel McCorkle shows up. Now, she's in Ottawa. Mr. Warman's in Ottawa. Is there a connection? We don't know. Isabel McCorkle was the long-estranged sister of the late Robert McCorkle. She didn't go to the funeral. She did not contest the will. Suddenly, she says she wants the will revoked because, get this, contrary to public policy. So she went to court to get she made an application basically to stop the distribution of the will until such time as she could challenge it. So she won that application, and she then brought an application to set aside or nullify the will, and that was heard in January of 2014 in the province of New Brunswick before the Court of Queen's Bench. Now, once that happened, we, the Canadian Association for Free Expression, decided we had to intervene. In other words, we wanted to get in on this case for a couple of reasons. First of all, this is very much about the right of freedom of belief and freedom of speech. And it doesn't matter whether McCorkle gave to a left-wing or a right-wing group. That doesn't matter. He had, in my opinion, and in the opinion I think of most Canadians, the right to his own opinion and the right to pass his wealth on to the people he chose. Interestingly, intervening on the other side was the Attorney General of New Brunswick, who obviously believes that the state has to approve your bequests before you're entitled to pass your wealth on. And of course, two of the major anti-free speech lobby groups in Canada, the League for Human Rights of B'nai B'rith and the Centre for Israel and Jewish Affairs, which used to be called the Canadian Jewish Congress. So they were ranged against freedom of speech and property rights, where these groups in favor of freedom of speech and property rights was the attorney John Hughes for the estate and the Canadian Association for Free Expression. Well, all these arguments were made in court, and I was pretty hopeful that we prevailed, that the traditional reluctance of the courts to intervene in a will would be upheld. Now, courts want to be very certain that this document, the will, is indeed the last, reflects the last wishes of the person who died, that he didn't in fact sign it, and he wasn't under compulsion, and he was of right mind, etc. But and that the will doesn't ignore any legal obligations that the testator or the dead person had. For instance, a man who has a wife and two small children, if he left all his estate to his mistress, the courts would overturn that on the basis that he was ignoring a legal obligation he had, which would be to support his wife and children. But generally, the courts do not meddle with the wishes of the testator, but on the belief that it's his property. And even if his bequest is foolish or wrong-headed, it's his money, it's his decision. Well, we were wrong. The Court of Queen's Bench basically took a double-barreled shotgun and blew the guts out of freedom of speech, freedom of belief, and property rights. Yes, they overturned in a June 2014 judgment, the Court of Queen's Bench in New Brunswick under Mr. Justice Grant nullified the McCorkle will with a lot of nasty comments about racism and so on, and even said that the National Alliance would have been a criminal organization in Canada. Now that's going pretty far. The National Alliance did operate in Canada for a year, from 2004 to 2005. It was never charged under any Canadian law, and obviously not convicted. So here was a judge making a finding where there had never even been a case, and obviously never an opportunity for a defense to be mounted. So that's where it stood. We believed, as supporters of free speech, that this could not be allowed to stand. So we appealed to the New Brunswick Court of Appeal, and that appeal was heard last June 2015 in Fredericton. And we're again very disappointed with the decision. It was a very terse, two-paragraph decision. Now, normally in an appeal, the decision will be quite long. It will summarize the arguments for the prosecution, summarize the arguments for the defense, and then indicate what the law is, and then come to a conclusion. This was two paragraphs. Basically, paragraph 1, the Court of Appeal adopted the views of the trial judge and upheld the nullification of the will. And paragraph 2 is a big slap across our face for even having the nerve to appeal. We were assigned costs to each of the other three parties of $3,000 each. Okay, that takes us to the summer of 2015. What do we do? Do we allow that decision to stand, that becomes a precedent? Or do we appeal? Well, that's not quite as easy as it sounds. An appeal to the Supreme Court, number one, very costly. and we're entirely self-funded. We don't get government money. How do we pay for such an appeal? But obviously, this can't be allowed to stand. So we took a big risk, and this is one of the reasons for this video. If you can help us financially, we really do need your help. Anyway, we filed what was called an application for leave. Now, you don't have an automatic right to appeal to the Supreme Court. So you have to file an application for their leave or permission. And the Supreme Court will look that over and decide, yes, we'll hear this case, well, we won't hear that. But they accept about 1 in 10 cases. And they want a case that will have, where the issue has national significance. Well, we think, and we argued that this case does have national significance. The right of a person to be able to pass on his estate as he sees fit is crucial. That was last August. The other parties in the case had an opportunity to send in their submissions as to why it should not, the court should not give leave. But in the meantime, things had happened. We've been assured by the judge in 2014 and by the other parties that this would be almost like a once-in-a-lifetime case. This was not going to be the thin edge of the wedge where people would be coming to the court and say, well, he gave to the wrong person, we don't like that group or that person. We were told, no, this will probably never happen again. Well, it did happen again. Early in 2015, an old Jamaican preacher named Spence had a estate of about $400,000, and he had 2 daughters. One he hadn't seen since he and his wife divorced for over 30 years, and the one he'd raised and put her through university, through law school, and so on. However, she ended up in a sexual relationship with a white man and had a child, and he strongly disapproved. So in his will, he gave her nothing and gave all the entire estate to the daughter he hadn't seen for 30 years. Well, the daughter who felt that she'd been done out of the estate went to court, and an Ontario court came down with a hard-hitting decision. Yes, the will was going to be revoked, this was racism, this was prejudice, and this will not be allowed, and blah, 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 blah. So that looked, that was an interesting development. Well, just recently, there was another case in Ontario. This was an old doctor, and he set up 2 bursaries, and the requirements for the bursaries were that one was for a male, one for a female. Both had to be a European or Caucasian race, not homosexual, and I believe single. Well, the court threw that one out. Then, just this past week, the Ontario Court of Appeals came down, and it reversed or overturned the Spence decision. In other words, it said Spence had the right, even if you didn't like his views, to dispose of his property as he saw fit, even if it was discriminatory. Okay, so that's the way it stands right now. In the Court of Appeals in New Brunswick says you don't have the right to pass on your estate if it's contrary to public policy in some way. Well, you know, all sorts of views are contrary to public policy. Supposing you're opposed to abortion. We have abortion on demand in Canada. Is that contrary to public policy? So the Court of New Brunswick says this, the courts should have the right to meddle. The courts in the Court of Appeals in Ontario says the courts do not have a right to meddle. So these cases are probably going to be joined, and we are hoping that the Supreme Court of Canada will grant us leave to appeal. We need your help. This is really very much an issue for all Canadians. It's freedom of speech, freedom of property, and at the bottom of the screen you will have our address. You can send us a donation to the Canadian Association for Free Expression. This is Paul Frog.